So, welcome everyone. Thanks for joining us on our very first home-based employment law webinar. We hope this is a format that you've all become pretty familiar with over the last few weeks. We're going to aim to keep the dogs and the cats and the small children to a minimum. I can't guarantee that the teenager who's turned day in tonight is going to be absent from this, but we'll do our very best. This is going to be a very short session. As you know, we may not have time for a lot of questions, but we would ask you to keep the questions to the subjects that we're going to be covering in the session. We know you're absolutely swimming in government and Google sourced information about the scheme. The object of this session is to do something slightly different. So we're going to focus on the things that we don't have good answers to. Now that's quite a strange thing for lawyers to say, but it's important for us to explain to you why we as lawyers can't interpret the government guidance reliably at the moment. And that's because it's come in the form of guidance. It isn't legislation, it's not regulations, it's just a policy statements, and it has to be read alongside employment law. So a lot of the things that have been preoccupying us have been how to read what is sometimes quite loose policy statements alongside existing employment law guidance. So we're going to jump straight into the questions. We've divided them up. They're all sort of the key topics that we think you need to focus on at the moment. So first question is what the scheme is for, and furlough against redundancy. So this is emerging as a bit of a concern amongst employment lawyers and tax lawyers, and it's sort of amplified to some extent by the huge take-up of the scheme, which you'll have seen referred to in the media recently. I've already explained to you that this is circumstances in which you'd normally expect some kind of clear guidance or a gateway or a set of qualifying criteria when somebody's trying to access state assistance. But we don't have that here. The initial statements by the government tended to focus on the link between furlough and redundancy. You remember it talked about the fact that you'd be furloughing people who you would otherwise be making redundant. The latest iteration of the guidance is slipping away from that a little bit, and it talks about the scheme being designed to support an employer whose operations have been affected by coronavirus. And then it says all employers are eligible to claim under the scheme, and the government recognises that different businesses will face different impacts of the scheme. As we'll come to see, that confusion remains, and it's played out in the application of the scheme, for instance, to people who are shielding. And Lynne's going to come on and talk about that. But originally, there was a freestanding statement about employees who were shielding. And now we've got a statement that says that you can furlough people who are shielding, provided they are also under threat of redundancy. So we have some conflicting statements there. But just for your purposes right now, there are two concerns that we have primarily. The first one is circumstances where you've got mixed reasons for a furlough. So a combination, for instance, of the COVID-19 effect and the oil price might be an example, or other trading issues. We don't know what the government will do and what HMRC will do about that. We don't know whether they will interrogate your reasons and the reasons for making redundancies. And the sort of next stage of that, a sort of subcategory of that, is furloughing people who you would have to make redundant anyway. You're going to make redundant irrespective of COVID-19. So where for instance, you've been planning redundancies, or for instance, at a later stage in this process, it looks like you are going to have to make radical cuts, permanent cuts, in order to deal with the economic impact of COVID-19. We don't know what the position will be with furlough in those circumstances. So having said all of that, the clue is in the name. So the name is Job Retention Scheme, and we suspect that the revenue will come back to that, and they'll be looking to make sure that what people are doing is using this as a mechanism for retaining workers as opposed to deferring redundancies that are otherwise anticipated. So the next subject I want to just cover is collective consultation. So again, another clue in the revenue guidance. It said this is an area in which legal advice is required, and we will urge you to do that. The reason consultation or collective consultation becomes an issue here is because the obligations are normally engaged when you're changing terms and conditions, because often at some stage in that process, you might be proposing to dismiss if you can't get agreement to the changes to terms and conditions. Now, there's a lot of, sadly, very unsatisfactory case law on when you might be proposing to dismiss and the timing of that. And the stakes are high because, as you probably all know, protective award claims are the only penal award in the employment law framework. So it's important to get it right. Our current view is probably that if you're furloughing genuinely with the intention to retain and you don't have a dispute with the employees about the terms of furlough, then it's unlikely that you're in proposal to dismiss territory, but everybody's circumstances will be different. A quick word on the special circumstances defence. Just looking at previous case law, we took the view that that was most likely to be useful for businesses that had to close down quickly. So the hotels and restaurants, for instance, are more likely to be relying on that than anyone else. Just finally, just on the question of collective consultation and employee representatives, we are seeing people do virtual employee representation, so employees who are working from home, and the use of Zoom and Teams, etc., to conduct collective consultation. It is not straightforward though, and if you have to do it, to some extent, you're going to have to take a pragmatic view about the best way to do it. We don't think that people will be dotting the I's and crossing the T's on the terms of the regulations as they stand. Next question for me. I get the lucky draw on holidays and furlough. This is a practical nightmare for everyone, and we know that. HMRC have been stoically silent on it, although employment lawyers all over the country are calling for some kind of clarity of the position on holiday. I've tried to pin down on the slides exactly what questions we know we can answer and we can't answer. So one, do the holidays accrue while you're on furlough? Yes, we think so. Can employees take holidays while they're on furlough? HMRC haven't said anything, but ACAS have said they think you can. There is a question mark amongst the more academic of us about how that interacts with the working time regulations, right to proper rest and relaxation. Can that happen while you're on furlough and you've had to cancel your 2 weeks in Tenerife? So that might seem like a very airy-fairy question, but it is there, it's out there, and I'll come back to the reason why that's important in a moment. Can they be forced to take holiday? Nothing in the working time regulations that allow you to require employees to take holiday have changed. Your own contract terms won't have changed in that sense. We know that some employers are adopting a sort of pragmatic policy and trying to make sure that people do take holidays, and I'll come back to the reasons why that might be important shortly. What do they get paid and what can be recovered? Again, unclear. HMRC haven't said that you can't claim holiday pay, but of course the working time regulations require you to pay normal remuneration during holiday. So should they come off furlough and get full pay, or will you be recovering part of the furlough and topping up? We don't have the answer to those questions, and I know that you're asking us that a lot, and I wish we could answer them. But again, that's one of the areas where we've got the various bodies within the employment law community asking HMRC to clarify the position. It is really important because we can see that employers are going to find themselves in a position, particularly if employees can't take holiday and they accrue them. We also then have this ability to carry over 4 out of the 5.6 weeks statutory leave into the next 2 leave years. And the idea that you would be trying to manage the accrued holiday entitlement of a whole lot of furloughed workers at the back end of a holiday year just is a commercial nightmare. So we think that effectively taking a view on that is something you're going to have to do and wait and see what guidance we get. There may be some, you just have to take a practical approach depending on how many employees you are, what makes sense for you and what you can afford. So I'm going to hand over to Lynne now, who's going to talk about wage costs.
Yeah, so thanks, Joan. Yeah, I'm picking up, still sticking on the theme of wages and pay. So you'll all be familiar with the newest guidance, which sets out quite clearly the formulas for calculating the wages, or what you include or what you can recover. So we know that for those on a salary, it's 80% of their salary or their basic pay. That's relatively straightforward. And there is now also provisions in there, formulas for calculating pay where somebody has variable pay. So that might be because they've got no normal working hours, like casual workers, or because they might work shifts. So they might get paid according to the hours that they work in a particular week. But we're still getting asked a lot of questions about what exactly does wages include, We know from the guidance that you can claim for regular payments, that you're obliged to pay your employees, and we know that that includes wages, it includes past overtime, fees, and it includes compulsory commission payments. But there is still some confusion, particularly over things like overtime. A lot of you will be very familiar with all the issues that we've had over the last few years grappling with holiday pay and how you calculate remuneration for the purposes of rewarding people for their holidays and what you pay them. And we now know that that includes things like voluntary overtime that's regularly worked in a pattern over a sufficient period of time. So one question we are commonly being asked is, do we have to include such kind of overtime when we're calculating wages, and can we recover that? And that really probably depends on whether the revenue intend that you use the holiday pay definition of pay, or whether we go back to employment law definitions of a normal week's pay, whereby if you've got somebody who is on fixed hours and work voluntary overtime, their normal week's pay for employment law purposes is generally their fixed contractual hours. So it does seem that you wouldn't include overtime for people that are on fixed hours and they're maybe working voluntary overtime. There is this reference to past overtime, which is a little bit curious, a little bit odd. That might be that what they mean is that if you are claiming, for example, in the first back period, say in March, you would be otherwise owed arrears of overtime that have been previously worked, and that's all they mean. And that going forward, as people are moving through furlough, they'll obviously not be working overtime as normal, and therefore that wouldn't be included in wages. But that is slightly unsatisfactory, and whether we get more guidance on it, we'll need to wait to see. I think for the time being, given that the revenue have made it very clear that they will be assiduously assessing claims and going back perhaps over a period of 5 years, given that's how long you've got to keep your furlough notifications, then it's possibly best to not claim for that and come to some sort of arrangement with your workers that you could reimburse them if it transpires later that overtime should have been included. So the next question I have certainly been getting a lot of recently is around furloughing employees who have left and who want to come back. I'm sure some of you have had that question, and the guidance is now very clear that if an employee was on your payroll on the 28th of February, but they left and they now want to come back and be placed onto furlough, it's clear that you can do that irrespective of the reason that they left in the first place. So originally it was only if they'd left on grounds of redundancy. Now, if they come back and they ask you, you can re-employ them even if they left because you dismissed them for gross misconduct, or if they just resigned and they've gone off to get another job, but sadly that job offer has been withdrawn. So we've had a number of, I think, employers worried that if they refuse to do this in circumstances where they have employees demanding it as a right, that will somehow be reputationally damaging to them. I'm sure you've all seen Martin Lewis, money saving expert, have a little bit of a Twitter campaign about all this particular issue. But it probably is a risk worth taking because there are quite a lot of issues arising or things that you would have to think about if you were going to take back somebody and then furlough them. And the first thing I think is probably really important is to consider whether you can in fact furlough them at all. Joan mentioned that the guidance has moved away from what originally stated about the circumstances in which you can furlough. So you can probably furlough people in a set of circumstances which is wider than what we traditionally understand redundancy to be in employment law terms. But if you are an employer who is maintaining your workforce and there aren't any particular bad impacts to you because of COVID, you might be delivering essential or key services, or we know a lot of employers in the finance sector are not generally furloughing, then it might be quite tricky for you to take somebody back and then furlough them if you're not really furloughing anyone else. We don't know what approach the revenue will take to that. They might consider that is a fraudulent claim, or it's a claim that shouldn't be made. Assuming that you could, however, do it and you are otherwise furloughing, there is many other sorts of issues that can arise out of this. So the first one is that if not drafted carefully, you're possibly going to create continuity of employment for such employees if they come back. So if you have employees who didn't have 2 years service, you might just be putting them into a set of circumstances where by the end of furlough they can acquire that, and they will get all the statutory employment rights that come with that when furlough comes to an end. You'll also potentially be extending the termination date, obviously, and that could mean that there are employees who might have been thinking about bringing a claim and going through the early conciliation process, you'll just have extended the termination date, and that'll give them longer to think about going to ACAS. Perhaps more importantly is all the other issues around, can you claim back payments that you've already made to them? So if they left and they received a redundancy payment, good pile-on, accrued holidays, do they have to pay it back if you take them back and then furlough them? The scheme doesn't say that they have to pay it back, and employment law doesn't say they have to pay it back. So that's going to have to be a matter for agreement with the employee if you do take them back. And then there are issues around back pay. Are you going to pay them for the gap when they weren't working and try and get reimbursed for that? And will you pay them at all actually while you're waiting to make the claim, or are you going to ask them to defer the right to be paid until you know your claim has been successful? So there are a lot of issues to think about, and a lot of employers, I think, don't really want to put themselves in the position of creating the admin burden of doing all of this. If you do decide to do it, and there might be good reasons why you do, then bear in mind you are going to need a really carefully drafted furlough letter to account for all these little differences and nuances. It's probably going to look quite different from the furlough notification that you're giving to other employees, so you should take advice on that. And also, if you're going to do it, just bear in mind that if you're getting multiple requests, if you're going to agree to one of them, then and not another, then bear in mind that that could lead to inconsistency of treatment, if you like, and you could expose yourself to risks of discrimination complaints unless you've got good reason for allowing one and not the other. So I think that's all the issues relating to that. The last little sort of rag bag of things I've got to speak about is sickness shielding, caring and the vulnerable. So quite a few things on one slide. We've had a lot of questions about sickness, absence and how you deal with that. And in particular, a lot of clients who don't just pay employees SSP but have occupational sick pay arrangements in place as well. And there's a question arising about, well, can we furlough those who are getting OSP? Probably where sick pay has been, statutory sick pay rather, has been exhausted. And then there just remains the question of, well, what do we then pay them if we furlough them? Do we pay them their contractual OSP, which might be half pay? Or can we agree with them that we're going to increase that and pay them what they ordinarily would have got? We don't know. So you're probably better to take the safer approach and pay them the OSP sum that they would have received if they're still off sick. The other one is around those who become ill while on furlough. What do you do with them? Do you have to move them off furlough and onto SSP? This presents a real issue, because if you have to move them off furlough onto SSP, which seems consistent with what the scheme is otherwise saying, they are going to drop their pay quite dramatically. And the real issue is that if they become sick halfway through a minimum 3-week period of furlough, whether you as the employer would be able to actually claim back for that whole period of the minimum 3 weeks, or whether it would break it and you can't claim back anything you've paid. I guess practically, once people are released from the obligation to do any work, are they going to bother telling you that they're sick? So I'm not sure if practically it will in fact come up much at all. We've then had the issue that Joan alluded to at the very start of the session about the change in wording to those that are shielding. So a lot of employers might, on reliance on the first guidance, have just simply furloughed people that are in that high risk category and shielding. But now we have guidance which says that there's this additional criteria, which is that you otherwise would have had to make them redundant, which seems really odd because it is not consistent with the moves that we've already spoken about in terms of the definition or the eligibility criteria for accessing the scheme. It doesn't sit with any of the conditions that are imposed on other categories, such as those with caring responsibilities. It just looks to be inherently discriminatory because a lot of these people will have disabilities. So we think it's probably a mistake almost, and that this might actually be rectified, but it does create a situation now where there might be a question mark over whether you can actually properly furlough shielding employees unless they would have been made redundant in the normal employment sense, i.e. that there's a diminished requirement for them to do work of a particular kind. We think it probably just means that there's no work for them to do because of the position they find themselves in, but it has raised a number of questions. And then we have in the new guidance the introduction of furlough for employees who are unable to work because they have caring responsibilities. So for example, childcare. And that I suppose makes a degree of sense, but it does create an issue for a number of employers who are getting multiple furlough requests from employees with caring responsibilities, but who still need to keep the show on the road. And they're really struggling with how they actually manage to deal with that, because they need those individuals to do work. I suppose in practical terms, is it better to just furlough them when otherwise they might just go off and say that they're claiming emergency time off to care for dependents? Probably the best thing to try and do with these individuals is to just communicate with them and explain why there is still work to be done. You need that work to be done, and what you're trying to do is make sure that the jobs are still there for when we come out the other end of this. So if you can work with them to try and work around their caring responsibility so that they're still able to do some work, that would seem to be the best practical approach in the first instance. And then the last thing I'm just going to mention is that there's nothing in the guidance actually about the vulnerable group. So that's the sort of group in the middle, so the ones that are not self-isolating or isolating and have entitlement to statutory sick pay, or at the other end of the spectrum who are shielding and are being told to stay at home for 12 weeks. There's nothing in the guidance about this middle group of the over 70s, the under 70s with underlying health conditions, or indeed pregnant women. We assume that with the more perhaps generous definition of when people might access the scheme, that it would also cover these individuals. But again, if you are a workplace that is open and you're not impacted by COVID, you've still got work that needs to be done, it might be essential work, how do you deal with these people? Because there are many employers that might say they can make the workplace safe for them to come in, and therefore that they should come in. If they want to stay at home, they should be unpaid. But you'll find in a lot of cases it might not be safe for them to come in. And what are you to do? Are you to let them stay at home and then suspend them on health and safety grounds? You'd be left in a position then of having to pay them full pay, which doesn't seem very satisfactory. So I think probably, but we don't know if the claim would be eligible, but it looks like these would be a category of people that you just can't maintain because of COVID, and that you might need to just furlough them and make the claim, recognising slight risk that you might not get the money back from them. And with that, I'm going to pass back to Joan, who I think is going to summarise where we've got to.
Yeah. So just to reiterate what I said at the very beginning, the take up of this scheme, as you probably know, is very high. There's not going to be any legislation. It's going to stay. We're just going to get repeated iterations of the guidance that we've already got. So we can only hope that the appeals that we've been making to the government to create a little bit more clarity on some of these issues does fix things in the longer term. In the short term, this is our top list of things that we want you to do to try and manage some of this uncertainty. The first thing is to keep an open line of communication to the employees, use FAQs, and get agreement to the approach that you take wherever you possibly can. We know this has been a bit of a movable feast. Some people hope that they would be able to communicate with the employees once and maybe not have to do it again, but that is just simply not going to happen. They remain your employees. You need to keep talking to them. Record and explain the decisions you take for any approach that you do take. And as Lynne was alluding to, we are worried a little bit about inconsistency in some cases. So make sure you've got a rationale for taking a particular approach, and try not to have that approach differ between different employees or groups of employee. Include a right to vary the payments in accordance with the rules of the scheme in your furlough letters. It's a fairly basic, a fundamental tenet of most of the furlough letters that are going about, but make sure it's in there. Build in a margin of error in relation to reimbursement. As we've already alluded to, there may be circumstances in which you're furloughing people with your fingers crossed in the hope that you'll actually be able to make the claim. If you're in any doubt about eligibility categories, again, I think caveating the furlough letters is a good idea. So for instance, where Lynne was talking about overtime, it may be that you pay people the basic pay for now and delay payment where qualification isn't 100% clear. So I think those are the key sort of practical solutions that we've got in the short term. But I hope that helps to explain to you why it is that when you look on Twitter and when you look on the Google at the moment, you will see such a huge range of information. I should also say that at the very start of the slides, and we will be circulating the slides, but at the very start, we've got a link to an extremely detailed note that goes through a huge range of questions, which is a link to our workbox guidance note, which we've given open access to just for a short period for the people signing up to this webinar. So you'll be able to see what we're saying about a whole range of other questions. We're very tight for time. Unfortunately, we've got about 4 minutes. We will try and pick up a couple of questions. Lynne, do you want to see what you can see?
Yeah, so we've got one question on holidays, and what do you do? So Joan, you might be able to answer this. What do you do if an employee is saying they want to reschedule holidays that they've already got booked in?
Yes, I think this is the people on furlough who think that maybe what they know that they can accrue their holiday and they want to go and cancel holiday. And this is all about your inherent right to insist that people take holidays at particular times. You need to have a look at your policy and see what it says about unbooking holidays that you've already booked. That will usually be by consent. And it may be that you've got a good reason for saying to people that you need them to keep their holidays, and that may link back to your need to be able to manage the use of holiday at a later stage. Obviously, you'd be careful about doing that if you were not topping up pay during the holiday period. I think you should probably still be doing that. Otherwise, you could have an argument there. But that's a tricky one. I think that's the best answer I can give to that at the moment.
Okay, and then we've got a question on shielding and what you do if you have put somebody on furlough if they are shielding, but relying on the first set of guidance. What happens if revenue say that you've done it wrongly? That one is a bit of a tricky one. If the revenue are going to say that you're not going to get the money back, because now you've got to be able to show that they would have otherwise been immediately redundant. There doesn't really seem to be a route to deal with this other than to go back to the revenue and actually challenge it. And if you can't get any way through that route, there doesn't really appear to be any sort of tax tribunal route that you can go down. The answer appears to be that you would have to judicially review the decision of HMRC, which seems entirely unsatisfactory given how much it would cost to judicially review a decision of HMRC. So I think we're kind of hoping that if that scenario arose, then we're going to end up hopefully getting something from HMRC that gives a route for challenge for decisions that might arise out of some of the inconsistencies between the various iterations of the guidance.
That's right. Got one more question here about rotation of furlough. I think that's come up quite a lot. I mean, the government have confirmed it over the last weekend. They confirmed that you could rotate, but I think you have to have the person off properly on furlough for 3 weeks, and then we've got quite a lot of employers who are rotating teams on 3 weekly cycles. What you can't do, we think, is ask the person to do a little bit of work while they're on that 3 week rotation. That doesn't work. The point about being on furlough is that you are not allowed to be doing any work for the employer. Another question that's come in very quickly is what happens if you have employee representatives who are on furlough? What happens if you're having to engage with them while they are being furloughed? Logically, we think that they are engaging a statutory duty. They're not working for you. So we can't see that would break furlough. But we think that the sensible thing to do would probably be to pay them some form of top up if they're having to do that, fulfill those additional duties on a number of days in order to get a consultation or collective consultation that you enter into organised. So we think that probably makes sense. I think we really are running out of time. That's exactly 12:30. I think we're going to stop there. We're really sorry that we have literally, I'm not going to tell you how many questions we have, but there are a lot. We will do a quick run through. If there are a lot of these questions, I can just see immediately a lot of the answers are on the link to the document on Workbox that I've told you about. If you don't know what Workbox is, please click on the links and have a look. It's our system for maintaining our contact with our existing clients. It's a superb system. And particularly at the moment, it would be invaluable for a lot of you. Check the answers there. If not, come and talk to us. But I'd just like to finish by saying thank you very much for dialing in. Thanks for your attention. I'm glad that my teenage son didn't make an appearance, but apart from that, thanks to everybody. We look forward to continuing this series as we go along. Thanks. Bye.
Thank you.